Today, we've got some big news from the world of luxury fashion that might just have implications for us watch enthusiasts. Hermès, the iconic French brand known for its exclusive Birkin bags, has found itself in hot water. A recent lawsuit alleges that the company uses coercive tactics, forcing customers to purchase additional items they might not want, just to get their hands on the coveted Birkin. Now, if you're a watch collector, this sounds very familiar. We've all heard the stories about Rolex and the high-end brands. Tales of customers having to buy less desirable watches or accessories just to secure their spot on the waitlist for that Daytona or Submariner. It begs the question, could Rolex be the next luxury brand to face legal scrutiny over its sales practices? In this video, we're going to dive into the details of the Hermès lawsuit, explore the parallels in the watch world, and discuss what it could mean for the future of luxury watch buying. This is a story that could have major implications for collectors like us. Now, I'm not an attorney, but as an economist, I can comment on the antitrust issues raised in the lawsuit. It's very likely that an economic analysis would determine the outcome of this case and whether Rolex should be looking over their shoulders. The lawsuit centers on so-called tying agreements. Tying is when a company says, if you want to buy product A, you also have to buy product B. In legal terms, product A is the tying product and product B is the tied product. Now, tying arrangements aren't always illegal, but they can cross the line into antitrust territory if two factors are present. Number one, the seller has significant market power in the market for their tying product. In other words, they have a lot of economic clout and consumers don't have many alternatives. Number two, this market power allows the seller to force customers to buy the tied product even if they don't really want it. In the Hermès case, the plaintiffs are arguing that Hermès has substantial market power over Birkin bags. These bags are so coveted, so exclusive, that Hermès can basically dictate terms to customers. They're alleging that Hermès is leveraging this power to force customers to buy other products they might not otherwise purchase, like scarves, jewelry, or less popular handbags. It's a bit like if you went to a car dealership to buy the latest sports car and they told you, sure, we'll sell you that car, but only if you also buy this old clunker that's been sitting on our lot for months. If you really want that sports car, you might feel you have no choice but to accept the package deal. In the watch world, this could translate to a brand like Rolex telling customers, you can get on the wait list for that Submariner, like me, but only if you also buy this less popular model or some branded accessories. Defining the relevant product markets is absolutely crucial in an antitrust case like this. It's the first step in determining whether a company's practices are actually anti-competitive. Let's break this down in the context of the Hermès lawsuit and a potential Rolex case. In the Hermès situation, the key question is whether Birkin bags are in a market of their own, separate from other products that customers are allegedly being forced to buy. To determine this, economists would look at factors like, number one, cross-elasticity of demand. If the price of a Birkin bag goes up, do customers switch to other luxury handbags instead? If not, it suggests that Birkins are in a league of their own. Number two, product characteristics. Are there unique features or qualities that set Birkin bags apart from other high-end handbags? Number three, do consumers see Birkin bags as a distinct category or just one option among many luxury handbags? If the evidence shows that Birkin bags are indeed their own separate market, it would support the argument that Hermès has significant market power and that their alleged tying practice are very problematic. Now, let's consider how this might play out in a potential case against Rolex. The tying products would be those highly coveted steel sports models like the Submariner, Daytona, and GMT Master 2. The tied products could be the less popular watches or branded accessories that customers are allegedly being pressured to buy to get their hands on the steel sports models. Defining these markets could be tricky. There's likely to be a debate about whether different Rolex models are truly separate from each other. For example, are steel sports models a distinct market from gold or two-tone Rolex sports watches? Are Rolex sports watches as a whole a separate market from Rolex dress watches like the Datejust? And taking a step back, are Rolex watches in general a separate market from other luxury watch brands like Omega, Patek Philippe, or Audemars Piguet? The answers could depend on detailed economic analysis of consumer behavior and market dynamics. If steel sports models are found to be in their own market and Rolex is determined to have a dominant position in that market, then any tying practices would be much more concerning from an antitrust perspective. But if the court sees all Rolex models as part of the same market, or views Rolex as just one player in a broader luxury watch market, then it might be harder to make an antitrust case stick. This market definition exercise may seem abstract, but it's absolutely essential. It lays the foundation for evaluating whether a company's practices are truly harming competition and consumers. What are your thoughts? Have you personally felt pressure to buy to get on a wait list? Do you have any personal stories that you want to share? Market power. That's the key issue in any antitrust case involving tying arrangements. It's not enough for a company to simply offer products together. They must have the economic clout to force customers to buy something they don't want. Let's unpack this in the context of the Hermès lawsuit and a potential Rolex case. In the Hermès situation, the plaintiffs will undoubtedly point to the extraordinary prestige and exclusivity of Birkin bags. They'll argue that for a certain segment of ultra-wealthy consumers, no other handbag can substitute for a Birkin. It's the ultimate status symbol, and Hermès has a monopoly over it. They'll likely present evidence about the incredible scarcity of Birkins, the long wait lists, sound familiar, and the astronomical resale prices. All of this would support an argument that Hermès has significant market power in the market for these iconic bags. On the flip side, Hermès will probably contend that the luxury handbag market is actually quite competitive. They'll point to other high-end brands like Chanel, Louis Vuitton, or Prada, arguing that wealthy consumers have plenty of options if they don't like Hermès' sale practices. Take it or leave it. They might present data showing that demand for Birkins is sensitive to price increases, suggesting that consumers do see other bags as reasonable substitutes. The court will have to weigh this evidence to determine whether Hermès truly has the market power to coerce consumers into buying. Turning to a potential Rolex case, the market power question becomes more complex. On the one hand, certain Rolex models, especially the steel sports watches, have an undeniable aura of exclusivity. The Submariner, Daytona, and GMT Master II are icons in the watch world, with wait lists that stretch for years and secondary market prices that are still above retail. This could suggest that Rolex has a substantial market power, at least for those specific models. A plaintiff might argue that for certain watch enthusiasts, no other brand can substitute for a steel Daytona. However, Rolex would likely counter that the luxury watch market is fiercely competitive. They might argue that while Rolex is certainly a prestigious brand, consumers do have meaningful alternatives. If Rolex were to dramatically raise prices or restrict supply, enthusiasts could turn to other high-end watchmakers to get their luxury fix. Evaluating these arguments would require a deep dive into the economics of the watch market, something that we do here all the time. Factors like Rolex's market share, the elasticity of demand for their products, and the barriers to entry for new competitors would all come into play. By the way, Rolex, if you want to call me, I think I can help you out. I'm still waiting on that sub. Now, if a court were to find that Rolex does have significant market power, at least for certain models, then any tying practices would be much more legally risky. But if the evidence suggests that Rolex is just one player in a competitive luxury market, then an antitrust case might face longer odds. Coercion is another key factor. It's not enough for a company to simply offer a package deal or encourage additional purchases. For a tie to be illegal, the seller must be leveraging its market power to enforce consumers to buy something they don't want. In the Hermès situation, the plaintiffs are alleging that coercion is explicit and systematic. They claim that the customers are being told point blank that they cannot purchase a coveted Birkin bag unless they also buy a certain amount of other Hermès products, whether that's scarves, jewelry, or less popular handbags. If this allegation is true, it would be a textbook example of an unlawful tying arrangement. Hermès would be using its market power over Birkins to force consumers to buy other products, not just encouraging them. The key evidence here would be consumer testimony and internal Hermès communications. If emails or sales guidelines show that Hermès has a policy of conditioning Birkin sales on other purchases, that would be a smoking gun. On the other hand, if the evidence shows that buying other products merely improved a customer's chances of getting a Birkin, or that different sales associates had different approaches, that would suggest persuasion rather than coercion. Now let's consider how this might play out in a potential case against Rolex. The Rolex waitlist system is infamous in the watch world, but it's also highly variable and opaque. Different authorized dealers have different approaches, and a lot seems to depend on individual relationships between customers and salespeople. In this context, proving explicit coercion could be a challenge. Unlike the alleged Hermès policy, there may not be a clear company-wide directive conditioning steel Daytona sales on purchases of gold Cellinis. Instead, the alleged tying might take the form of subtle pressure or suggestion. A dealer might tell a customer that their chances of getting the Submariner they want would be improved if they bought a less popular model first. Or they might give waitlist priority to customers who have a history of making other purchases from the store. I know for a fact they do that. Persuasive as these tactics might be, they don't necessarily rise to the level of illegal coercion. A key question would be whether customers feel like they have a real choice. If a dealer says, "I can't guarantee you a Submariner unless you buy this Datejust," that's a lot different from them saying, "If you want a Submariner, you absolutely must buy this Datejust first." Proving coercion in a Rolex case would likely require a deep dive into the specifics of how different authorized dealers operate. Plaintiffs would need to find clear evidence that customers are being denied access to steel sports models unless they make other purchases. This could be a tall order, given the individual variation in the waitlist system, but it's not impossible, especially if there are patterns or unofficial policies that emerge across multiple dealers. In my videos, I've spoken about feeling pressured from certain ADs. I talked about how in one instance, I immediately walked out of the store. At the end of the day, the coercion question comes down to consumer choice. Antitrust law doesn't prohibit companies from offering bundles or encouraging additional purchases. What it prohibits is using market power to eliminate consumer choice and force unwanted purchases. In the luxury goods context, this could be a fine line. The exclusivity and prestige that give brands like Hermès and Rolex their market power are also what makes consumers eager to jump through hoops to get their products. Distinguishing between savvy marketing and illegal coercion would require careful economic and legal analysis. The stakes are high, not just for the companies involved, but for the future of high-end retail. For watch enthusiasts, the implications are especially profound. The way courts interpret coercion in the context of waitlist and allocation systems could reshape the entire hobby. It could determine whether these hard-to-get Rolexes become a bit more accessible, or whether the game of relationship building and strategic purchases become even more intense. As we've seen, the strength of the Hermès lawsuit and any potential future case against Rolex will hinge on the economic evidence. Plaintiffs will need to prove several key elements to make their case, and each of these elements will require vigorous economic analysis. First and foremost, they'll need to demonstrate that the defendant has significant market power in the tying product market. For Rolex, they have to prove that it has substantial market power over certain coveted models like the Submariner or Daytona. Secondly, plaintiffs would need clear evidence of this coercion. They can't just show that the defendant is encouraging or incentivizing additional purchases. They need to prove that consumers are being forced to buy products they don't want in order to access the tying product. Finally, plaintiffs will want to demonstrate that the alleged tying is having a substantial effect on the market for the tied product. They'll look for evidence that the practice is foreclosing a significant volume of sales in that market or making it harder for competitors to vie for those sales. The stronger the evidence is on each of these points, the more compelling the antitrust case will be. Plaintiffs will want to paint a clear economic picture of a dominant firm using its market power to coerce purchases and stifle competition. On the flip side, defendants will seek to undermine this picture at every turn. They'll question the market definition, arguing that consumers have more alternatives than plaintiffs suggest. They'll contend that any bundling or additional purchases are the result of persuasion, not coercion. And they'll try to show that their practices haven't meaningfully harmed competition in the tied product market. Whoever makes the most convincing economic case is likely to prevail. This means both sides will be marshaling extensive data on sales patterns, consumer behavior, and market dynamics. Kind of like what we do here. This case is very complex, so let me know if you want a follow-up video. That'll also depend on the outcome. Ultimately, these cases serve as a reminder of the complex economic dynamics at play in the luxury goods market. By staying informed about these issues and being thoughtful about our own participation in the watch market, we can help ensure that our hobby remains vibrant, competitive, and fair for all. The battle over luxury time may be fought by economists and lawyers, but the outcome will affect every one of us who loves watches. See you in the next video.